July 4th, a boat full of friends heads out to Horn Island, a remote barrier island off the Mississippi coast. 18-year-old Nolan Wells, a football player, a college freshman, somebody's son, goes with them. His friends leave without him. His body is found later. The sheriff's office has a working theory: accidental drowning, no evidence of foul play. Nolan's family has a very different read, and they've hired a civil rights attorney to say so publicly. Somewhere between those two positions sits a question this entire series has been building toward. When the people who loved him say this doesn't add up, and the sheriff's office says there's nothing to see, who's supposed to be right, and who decides? This is not a cold case. It's happening right now, this month, with the sheriff's office and a family publicly disagreeing on camera about the single most important fact in the entire story. Was this an accident or was it? Was it a crime or wasn't it? Everything I'm about to show you, you can watch develop in real time, which makes it the clearest live example this series has of the exact question I opened with. Welcome to Help Solve the Case. I'm Christine Burke. This is episode 3. Nolan Wells. Wait for the medical examiner. Here's what's not in dispute. Nolan went to Horn Island on July 4th with a group of friends. At some point, he stayed behind while the others left. His body was recovered later. The sheriff's office public position has been consistent: accidental drowning, no evidence of foul play. Here's what's in dispute. Attorney Ben Crump, representing the family, says investigators were told there's no evidence of foul play, quote, even though you have students who recorded an altercation while they were on the boats, end quote. His description on camera: Nolan and another person were, quote, yelling at one another, end quote. I want to be exact about what is and isn't. A recorded argument on a boat is not evidence of a specific cause of death. It is evidence that something happened that the family believes was never fully run down before the sheriff's office settled on its working theory. The family didn't stop at disputing the theory publicly. They paid for an independent autopsy. It came back inconclusive: cause of death undetermined. That's not a win for either side, and I'm not going to pretend it is. An inconclusive independent autopsy doesn't prove foul play any more than the sheriff's working theory disproves it. What it does is keep the file genuinely open in public on a case that's still active. In their own words, the family has said the accidental drowning conclusion made, quote, both me and his father uncomfortable, end quote. That's the entire ask. Stripped down, not a demand for a specific verdict, just transparency before the door closes. Notice who showed up to the podium. Not just a family and their attorney. The NAACP standing alongside them. That's not incidental to this story. When a Black teenager dies under circumstances a family disputes, and the agency investigating settles quickly on the least scrutinized explanation, there's a specific, painful history in this country of families needing outside institutional weight just to get a second look taken seriously. I'm not telling you that's what happened here. I don't know that, and neither do you yet. I'm telling you it's the lens a lot of viewers watching this case are bringing to it. And pretending that context doesn't exist would be its own kind of dishonesty. I told you in episode 1 about the unofficial rule most agencies run for on adult disappearances. Wait 24 to 48 hours before treating it as anything but voluntary, because most missing adults come home on their own. Wells's case isn't a disappearance in that sense. His body was found, but the same underlying instinct is doing the same work here. As the sheriff's office reaching for the least urgent explanation first, because statistically, it's usually right. Most drownings are drownings. Here's my training talking, and I want to be precise about it. A body recovered from water after time in the elements presents real limits on what any pathologist can establish. Water accelerates decomposition. It can mask soft tissue injuries that would otherwise show a struggle, restraint, or incapacitation before someone went into the water. Undetermined isn't evasion. Sometimes it's the honest sealing of what remains can still say. That's exactly why the training principle exists. Every death gets treated as a homicide until the medical examiner says otherwise, because you don't get a second chance at evidence a decomposing body stops giving you. Now put yourself in the sheriff's office position, because fairness cuts both ways in the story. No evidence of foul play is often the safest thing an agency can say publicly. It commits them to nothing. It isn't an accusation and it isn't a clearance. It's a placeholder. The problem isn't the statement. The problem is what happens if a department starts treating that placeholder as a conclusion and quietly moves resources off the case as if the questions were already answered. There's a resource reality underneath this too, and it's different from Guthrie's in an important way. Pima County, where Guthrie disappeared, has real institutional resources. A large sheriff's department, a national press corps parked on its doorstep, the FBI showing up within days once they were finally let in. Jackson County, Mississippi is a much smaller jurisdiction with a much smaller budget, a much smaller detective bench, and a coroner or medical examiner system that almost certainly doesn't have the staffing depth Pima County does. I told you earlier that the country needs to roughly double its number of board-certified forensic pathologists just to meet demand. And that shortage lands harder exactly in counties the size of this one, not the ones with cameras already outside City Hall. That's not an excuse for getting it wrong. It's context for why an inconclusive result here might be a resourcing problem as much as a mystery. Here it is directly. Should law enforcement reshape an investigation? Spend the money, redirect the detectives, reopen the classification because a grieving family says this doesn't add up? Or does everyone, family included, have to wait for the medical examiner before the case moves at all? I don't think there's a clean answer, and I'm suspicious of anyone who gives you one. Move too fast on a family's conviction alone, and you can burn resources chasing a theory the evidence never supported. Every hour spent on that is an hour not spent on the actual answer, whatever it turns out to be. Move too slow, wait for the medical examiner as a reason to do nothing else in the meantime, and you risk exactly what happened in Guthrie's case. A scene that degrades, footage that gets overwritten, a window that closes while everyone's waiting for a stamp of certainty. Here's where I land, and you can disagree with me. The family's belief shouldn't dictate the classification, but it should absolutely dictate the follow-up questions. Crump's claim about the recorded altercation isn't proof of anything, but it is a specific checkable claim. Was that footage collected, logged, chain of custody documented? Those questions cost almost nothing to answer, and they don't require abandoning the working theory. They just require treating "we don't think this is foul play" as a starting point for more questions, not a stopping point for all of them. I'll give you the strongest version of the sheriff's office argument too, because a fair breakdown means arguing both sides. If departments reopened their working theory every time a family pushed back publicly, investigations would never stabilize. Every case would be litigated in the press instead of in a case file, and the loudest, most media-savvy families would get more resources than the quiet ones, regardless of the actual facts. That's a real risk, and it's not a small one. Attention is not evidence. A well-run department has to be able to say, "We've looked, and here's what we've found," without reopening the entire theory every time someone with a platform disagrees. But here's the counterargument, and it's the one I keep coming back to. Nolan Wells' family isn't asking the sheriff's office to change its conclusion. They're asking whether specific, checkable investigative steps happened. Was the altercation video collected? Was it analyzed? Was every witness on that boat interviewed on the record? Those aren't demands to reopen a theory. They're the baseline of what "we looked" should already mean. If the answer to those specific questions is yes, the sheriff's office should be able to say so specifically, and this entire public dispute mostly evaporates. The fact that it hasn't evaporated itself is information. There's a prosecutor in this story too, and it matters. The family met with the Jackson County District Attorney's Office, and by their attorney's account, it was a respectful conversation, which tells you the DA hasn't closed their door on this file either. A DA doesn't need to publicly declare a theory to keep a case alive. They need the sheriff's office to keep building the file as if charges were still possible, not as if the manner of death were already decided. Let's talk about what happens to this file from here, because it teaches you something almost nobody explains about how cases like this end. If Wells' death is ultimately ruled an accident, this case never enters the FBI clearance statistics at all. Accidental deaths aren't crimes, so there's no cleared or unfounded category waiting for it. It simply closes. If new evidence changes the classification to homicide and a suspect is charged, it's cleared by arrest, the category that matches what you think cleared means. And if investigators come to believe they know what happened but can never prove it to a prosecutor's standard, the case can sit open indefinitely or get closed as exceptionally cleared years from now under a theory the public may never fully see tested in a courtroom. 3 completely different endings, and right now nobody, not the sheriff's office, not the family, not me, knows which one this becomes. That uncertainty is the entire reason this episode exists. The FBI's own 2024 numbers show violent crime clearing at 43.8% nationally. And that's for cases everyone agrees are crimes from the start. A case that might not even be a crime carries none of that structure, none of that accountability, and none of that public tracking. It just sits in a much quieter category. Undetermined, unresolved, and unless a family keeps fighting for attention the way Nolan's has, largely invisible. I want to flag the exceptional clearance path specifically, because it's the one that should worry you most if you're this family. That category only requires that a department believes it knows what happened, not that a prosecutor agreed, not that a court ever heard it. If years pass and this case is still unresolved, there's a real documented pattern nationally of cold cases eventually getting closed under exceptional clearance, attached to a theory that's convenient rather than proven. Often, once the most likely person in the department's mind is dead, unreachable, or otherwise can't be tried, researchers who track clearance data, including the Murder Accountability Project, have flagged exactly this vulnerability. A rising exceptional clearance number doesn't always mean better police work. Sometimes it just means a more convenient way to close the file. I'm not saying this is where the Wells case is headed. I'm telling you it's a real door that stays open the longer a case sits without an arrest, and it's a door families should know exists. 2 cases, 2 different sheriffs, 2 different counties. One with the resources of a national spotlight, one without it. Same decision point playing out on 2 different timelines. One where we already know the classification costs time and evidence. One where we're still watching it happen in real time, argued out in press conferences instead of a courtroom, with a family that isn't going away and a sheriff's office that hasn't moved off its first answer. Next episode, I'm putting on a real number on what all of this costs. Not just Guthrie's search plane or Wells' dueling autopsies, but what it costs the department in dollars to take an uncertain case seriously versus what it costs to get wrong. And I'm asking the harder version of today's question. Should a department spend big because a family or a news cycle said it should? I'll see you there. Before I go, I want to leave you with this version of this question that actually matters once the cameras leave. It's not, was the sheriff right or was the family right? It's, did anyone treat the uncertainty itself as worth investigating instead of just picking a side and defending it? That's the series here in one sentence. I appreciate you being here. This has helped solve the case, and I'll see you on the next one.